because, as I stated previously, I was in fear of my life due to certain enemies I made in this community. As a long-standing resident, 45 years, 47 years in the state of Nevada, including a 30-year law enforcement career. And I wanted to find out.
Alex here with a little bit of bad news. I need to give an explanation before I start this video. When our Nevada judge's personnel went to record this hearing, apparently Channel 4 personnel and Channel 8 personnel also showed up. It was decided that Channel 8 personnel would record the proceeding and share the footage with the other camera teams. This is actually something that's relatively common. It's called pooling, camera pooling. This is the first time that our Nevada judges has had to do this. All of the other times when other media showed up, the judges allowed both cameras to be deployed. In this particular situation, only one camera could deploy. Channel 8 personnel apparently did not know to record the entire proceeding. They only recorded the first half of the proceeding, and then you're going to see some hiccups throughout the proceeding. Apparently, this is standard practice for them and other mainstream outlets. Apparently, mainstream outlets typically don't publish the entire proceeding anyway. They'll talk about it on the news, or they might just draft an article and post a link to a little snippet in the article. So they have been, to their credit, reaching out to us to sort of coordinate going forward to prevent this from occurring in the future. The news director from Channel 8 has called me twice. So I can definitely tell that it matters to them, that they care a lot about this, about working with us in the future, and eventually I'll be able to give them a call back. They called both times when we were broadcasting live in State of Nevada versus Blandino. So sorry about this particular hearing. The best we can do is publish what we have. So even though it's incomplete, I don't think it's going to happen again going forward. And if this was going to happen, it's better that it happens now than at the jury trial, because that is really what we want to make sure we get 100% of. So with that said, let's go ahead and start the hearing.
The Second Judicial District Court of the State of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. Okay, we're on the record in case number CR 19-1535B, State of Nevada versus Stewart Handte. The CR 19-1535A case, State of Nevada versus Roger Hillegas, continues to be stayed. Mr. Hillegas remains, as the court understands, on pending warrant status. Today, the court wants to hear argument on the four pending motions. Motions being the defendant petitioner's motion for writ of habeas corpus. Also, the defendant petitioner's motion to suppress or dismiss. We also have the defendant's motion for reasonable bail. And then we have the state's motion for a gag order. At this time, I invite the state to make its appearance on the record, followed by defense counsel, and who can introduce his client, Mr. Stege.
Good morning, Your Honor. Amos.
Thomas Pitaro for Stewart Handte, who's seated to my right.
Thank you. Good morning to you both.
Good morning.
Mr. Pitaro, let's make sure that you had enough time to visit with Mr. Handte in person this morning. I asked that he be brought down from the Washington County Jail well in advance of the hearing this morning, and that you and he have an opportunity to meet in person, I believe in the jury room if that was available or somewhere else, to give you enough time to see each other in person. Did that occur, and have you had enough time to talk to your client?
Yes, it did, Your Honor. They were very accommodating, and we spent at least 20, maybe 30 minutes in there talking, going over what we were going to do today.
Good.
In that light, could I, it's a motion that has been pending out for a period of time.
Mr. Handte, is that correct?
Correct.
Right, thank you.
And,
Withdrawn?
and just one other thing, I'm not being rude, but if I could just make the gesture that I'm standing up, I've been having back problems.
You may address the court seated.
Thank you.
You're welcome. All right, so let's start with the motion for writ of habeas corpus, ending the longest. After that, we'll hear on the request for a change of bail status for Mr. Handte, and then we'll move to the state's motion for a gag order.
Do you want me to podium, do we?
You may address the court seated from council table.
Let me do that. if I may. Your Honor, if I could just give you first the overview of the motions, the writ of habeas corpus, the petition, of course, and the appointed authorities, we are confined to the four corners of the indictment and what was said in the grand jury. Because of the nature of the issues that they're so interrelated, they're basically the same issue, we filed also a motion to dismiss / suppress. Now, given that suppression aspect of it, it was my belief that the court was going to defer those motions until that motion calendar you spoke about earlier in the case, into April, because we were potentially going to have witnesses. The way the court has scheduled these things, I assume, to do it by myself, there would be no witnesses, and therefore although I'm out seeking a particular witness, I haven't got that far yet. So, I think if the court understands that, I can still make the issues, and if I'm dissatisfied or I think further motion with an evidentiary hearing should be necessary, I'll ask the court for that.
Well, I'm going to make sure I understand. So to the first week of May trial date, because there may be an evidentiary hearing, and in which case we don't go forward today? Or do you say I'm going to make argument to the court on my motion now, rule as you see fit, and we'll decide at a later time if there's still pieces or new issues that have arisen?
The latter is correct, Your
Okay.
Honor. I think, saying we've gone this far and we've briefed and both sides are, I think, ready, and
notice also-
a better way to handle it.
Yeah, and the court order from early in February, I believe, indicated that we would be hearing these two motions
Right.
today. But I'm aware that we have a May trial date. I'm aware that we do have a final pretrial conference. I'm aware that I've previously indicated that any pending, submitted, but yet unresolved motions could be taken up at that time. So with that said, please argue in favor of why you believe the writ should be granted. And if you want to include at that time why you believe the case should be dismissed or evidence suppressed, make argument to the court, please, right now.
Thank you, Your Honor. We filed the petition for the factual way this thing is. If I could just take a minute or two to give you a timeline as it relates to Mr. Handte. Going back to the beginning, Mr. Handte was in the law office on seeking advice concerning something unrelated to this, where he met Mr. Hilligus. Mr. Hilligus and him started talking, and Mr. Handte found out that Mr. Hilligus was having a situation that reminded him of his aged mother and nursing homes. So that was how this issue got together on it. Both Mr. Hilligus and Mr. Handte having a lot of problems with the nursing home industry. And of course, that is strife through here. Based upon that, Mr. Hilligus informs Mr. Handte that he has had a court order voiding the custody guardianship turned the Washoe County court orders. And Mr. Hilligus informed that those had been filed in Washoe County, and he showed the front sheet, and they're part of the exhibits that we've addressed, I think on both sides in our various motions and on the writ, that the Washoe County face sheet, the form sheet's advice as to what to do. Mr. Handte, being 30-year retired law enforcement, had connections, if you will, with local law enforcement, and said, let me see if I can arrange a meeting with these people to allow you to facilitate the change of custody that you've got through this order out of California at this time. Mr. Tracy, Griffith, Tracy Griffith, Mr. Hilligus and Mr. Griffith meet for maybe an hour, 45 minutes with a sergeant of the police department, which is all recorded, and we all have copies of that. Shortly, and Hannafin says it's a civil matter, it's like, we don't get involved. Go out there and, see what you can do on your own, show them what your papers and talk to them and see what happens. Hilligus decides to go out there and he brings Tracy with him, and he calls Mr. Handte if he would come out there with him. Mr. Handte agrees, and he meets them out at the Stony Brook nursing home, the nursing home in question here. And they walk in, and this is where the problem starts, which is the gist of both the writ and the motion. There is a sign-in log there, although quite truthfully, it doesn't appear to be well used like you would expect in most places of signing in and making sure you're who you are. But in fact, there's a sign-in sheet. And Mr. Handte signs in. The sheet that he signs in as Stewart Handte. As I say, the signing thing is a very informal looking document. He signs in as Stu. He puts down next to him Gus, which is a nickname for Roger Hilligus. He puts down Gus, and he puts down the person he's going to see. He puts down Susie. That's Susan Hilligus. So he's written Susie, Stu, Gus. After that, Mr. Hilligus goes in, visits his mother, maybe even sees someone else there, takes his mother, and he's taking his mother with him. As he's walking outside, he crosses two individuals, one by the name of Campbell, and she acknowledges Mrs. Hilligus, and she says that she don't look distressed, everything looked fine with her. She says hello to her, etc. There's also another man in there that worked for the nursing home, and the conversation from Campbell and her is Campbell says, why is Roger taking his mother? And his response is, the son can take his mother out to dinner if he wants. And she says, well, I used to work here 2 years ago, and I know that there was some problems with Roger, and you better call his daughter, Mrs. Hilligus' daughter, Robin. They call Robin, and all hell breaks loose, because Robin has guardianship from the Washoe County. There's guardians set up. Now, as Mr. Hilligus is escorting his mother out, not dragging her, kicking and screaming, as Ms. Campbell says, she didn't look distressed. She looked fine, smiling.
Was she in a wheelchair at that time?
No, she was walking.
Okay.
Okay, obviously, I found out that your steps get shorter and shorter the older you get, and whatever. But nevertheless, the only thing is that the only adverse thing that sort of was said was they were hurrying her along, making her walk faster. They cross the street. She gets in the car with her son, and Roger Hilligus asked Handte if he'd give Tracy a ride to where his car was left, because Tracy had initially drove to the nursing home with Roger. Mr. Handte goes home, drops the Tracy off, goes home, and that's it. Unbeknownst to Mr. Handte, quite unbeknownst to anyone, Mr. Hilligus is taking his mother to visit, or taking to California to visit relatives, he says, down in Southern California. While that is going on, Mr. Hilligus has a conversation with the nursing home and a police officer there, and sends to them this document that was filed in the Washoe County Clerk's office that has all this "We the People" stuff in it, okay? So that's sort of an overview of it. Where the problem is, and the reason Mr. Handte is here, quite truthfully, and when we look at the information becomes that Stewart Handte arrived at the nursing home with Roger Hilligus and fraudulently put down names so that no one would recognize Roger be coming in. And that what they did is they copied names from further up in the sheet. Now, when they copied further up in the sheet, they put down the phony names. One of them, and it seems to be, it was something that was Alice. And so the allegations in the complaint and during this whole situation, Your Honor, has been that Mr. Handte fraudulently, with an intent to deceive, put down phony names so they would not know who was really coming into the nursing home to get Mrs. Hilligus. And when I say it was informal, I mean that's being, this didn't happen, the people are there, people are happy, they sign in. When Roger now takes Mrs. Hilligus on his own to California, then the wheels start going. Now we have an abduction of an elderly and he's left the state. And everyone becomes very, very concerned, as rightly you would expect under those circumstances. The problem is initially while they're in there, and we saw it on tape, and that's part of how we discern this, is the workers who had just, I mean, they were new hires too, they pointed to a sheet and said, he signed in there and he signed some name and it wasn't his. And the officer looks at it and, look, I don't see it, there anything that would indicate.
You're right to object to the, if Mr. Pitaro could refer specifically to the record, because here he's going off the record and this sounds more like a closing statement than the record below us. For example, I don't know what
These
video
issues
he's
he's raised so far were raised in part of the record and part of the basis for the petition, are they not?
up until the point where I objected.
Which was what?
A piece, he's referring to a piece of video that I discovered, Your Honor, he's saying, a piece of video in which, et cetera, et cetera.
Well, I haven't seen the video.
Right.
All right, so.
If it's not in evidence, there is no.
Okay, so just let's do this, as a caution. Everything, I'm tracking everything you've said to this point as part of the record the court has reviewed and part of the argument that's been made justifying a writ of habeas corpus or a dismissal. But just make sure you stay with things that are built into the record that I can go back and just take another look at, please.
Ms. Stege, that part of the police department and the charging document that Mr. Handte fraudulently placed phony names down so that Roger Hilligus could get in to get his mother. Now we have to.
Hold on one second. Mr. Handte, would it be easier for you if I asked the deputy to release your right hand so you can take notes easier?
I believe that would be correct, Judge.
All right, deputy, is there any security reason the court should be concerned with? Thank you, officer. All right, Mr. Pitaro, please continue.
Thank you. So that's where the affidavits and theory and has been the theory of the police and the prosecution throughout this case. Now, what happened, and it's a remarkable thing, the way what ultimately happened, but the police officers got the wrong sheets. As a matter of fact, Detective Barnes, about 2 weeks later, getting information after the charges had been filed, came across the fact that, oh my God, we were looking at the wrong sheets. Matter of fact, one of the names that they were given that Mr. Handte signed as a possible phony name, they called the man up and asked him, was he at the Stony Brook at the time? That was
Again,
indicated?
outside the record, Your Honor.
Well, that is.
It's outside the record.
Well, hold on, is part of the record
I
that
believe so,
the
yeah.
police called up the other fellow to ask if he was in at Stony Brook that
I
day?
mean, yeah,
Stonegate.
I believe it is, like,
But
ultimately,
Barnes did not
though,
testify.
Hold on, what is it?
Barnes did not testify, so
All right,
it
so
can be in the record.
the objection is, again, you're saying things that are not part of the record before the court.
that's fine, I don't need. What ultimately happens, Your Honor, is, and these are in the record, I looked at the tape, I looked at these things, and Stewart, you signed in phony names. And as this goes on in the course of the thing, now his interrogation, if you will, she says, you knew the We the People documents were phony. But no, I didn't. I didn't really look at them that close. I saw the cover sheets with Washoe County, that you would file in the Washoe County District Court. That's basically all I did. Well, that can't be. By the time she's done, oh yeah, I knew they were phony. California, time he's done denying it, she finally, you had to know. In other words, by the time the end of this confession is, whatever Detective Jenkins wanted said, got said. Starting with the most obvious thing, that she was arguing and telling Roger telling Stewart he was wrong and lying, when in fact, she had it wrong. That he was telling the truth, and she had it upside down. Now, that is really the gist of this whole case, and the basis of it. And when we look at the information, which let me just reference it if I could, Judge.
Go ahead, I have it up.
To give you an idea of what the charging document is. The Roger Hilligus, and I'm looking at page 2, the bottom of page 2, paragraph of style number 3, of having the setting up the meeting with the police is somehow being improper. Goes on and it says that they planned the removal of Susan Hilligus, one or more of the defendants entered the facility. One of the unknown third actor wrote a fictitious name in the visitor's log assigned in under the guise of visiting a resident. That was where Alice comes in. Or otherwise misinforming Stone Valley staff of their intentions. One or more of the defendants then escorted Susan Hilligus from the facility, and then they fled. And in other words, Your Honor, the gist of what it is he is charged with that leads to the second-degree kidnapping charge is exactly that. The allegation he signed the phony name, and 2.5 years later, the detective admits, no, I was wrong, he was right. And with the writ, and as it goes, you have to work backwards, because the burglary, of course, is an intent to commit a crime, and the intent is to go in and sign a phony name, which he doesn't do, and that's why there's nothing to sustain the burglary. And the conspiracy is the same thing, they conspire to do, but what it is to improperly gain entry in there by signing in as phony names, and then we have the conspiracy aspect of it. So the case is not difficult when you narrow it down to the gist of where this all starts. And it starts because the detectives had it upside down. And they never corrected the upside down. Even, as I said, 2.5 years later, the managing detective, the detective on this case, the one that did the interrogations, admitted, oh my God, it's upside down. He was right all along. So, there's other things involved, but you've read the paper, you've read everything. I think you understand it. But you have to look at, in fact, the sign-in sheets where on the day in question, 8/8/19, Susie was signed in, or Stu and Gus and the time. This is exactly the time and the date when all this happened. And then Tracy Griffith, who at times it appeared they thought it was unknown or whatever, he is the one who came in and signed to see Alice, and he signed in Tracy to see Alice at 2:15, 15 minutes later, while they're out there doing their things, and he testified also. So we have a tragic misinterpretation of the evidence that was clearly before him. And I don't know why it was done that way. Accident, sloppy work, whatever it was. I'm not here to make ad hominem attacks on anyone at this stage, save and except the fact that they were wrong. And because they were wrong, Roger has spent the last 3 years doing it. And if you look at the information, Your Honor, and you look at that timesheet or the sign-in sheets, and you look at what we said in there, I think that is why the writ should be granted. Do you want me to move into the?
Well, let me hear from the state at this point, and then we'll go to the motion to dismiss or suppress. So, Mr. Stege, the defense argument, it's that simple. The gist of why we're here, why Mr. Handte was charged, has to do in large part because of the manner in which he was signed in, his understanding of what was going to happen, that his role here, it was innocuous and modest, and that there's not enough evidence even to proceed to trial, and much less convict with evidence beyond a reasonable doubt. Why does the state disagree?
Well, he's wrong for a number of reasons, and first of all, just by the right now, to argue with passion that the case cannot be proven. I agree with, I think, two things that Mr. Pitaro said. One, we are bound by the record below, and
For
two,
purposes of the writ.
for purposes of the writ. And
Let's be clear, this is not the trial.
it's not the
It's not
trial.
to determine
No.
today whether there's evidence beyond a reasonable doubt to convict on any or all the charges Mr. Handte's faced.
Right, and I don't have to go to a preliminary hearing to dispel any argument that a defender would come up to district court and say, well, they were wrong. Here's a theory of innocence, right, to rebut what happened at the preliminary hearing. And remember, of course, in the grand scheme of things, you're not entitled to a preliminary hearing, right? Many systems don't even have a preliminary hearing. I mean, it's a very, very low standard. Slight, even marginal evidence. Any inference that the JP and in turn the court must adopt any inference in favor of the state. Instead, what we heard was a closing argument, right? What we heard just now. And turning to the moving papers, what we heard was a sort of, complaints that the JP did not adopt a defense favorable interpretation of the evidence. That's not what this is about. If there is any inference from the evidence per charge to bind the case over, the JP is bound to send it to district court, and absent, an extreme violation of that duty, the case should proceed to trial. On the subject of going back to the now, and why have I argued this? Because they want it to be about the sign-in sheet, that you cannot commit second-degree kidnapping unless there's a sign-in sheet involved. We hear anecdotal evidence. I've never been to a place where you don't have to go through high procedures to go into a place. That's not evidence. That's anecdotal evidence, means nothing, right? You can, as in this case, commit second-degree kidnapping with or without a sign-in sheet. Now, rebutting directly the sign-in sheet argument, we have in the record, and I think it's at page 350, line 3, where Detective Jenkins describes that Mr. Handte says he was told by Mr. Hilligus, use the false name Gus, sign in under the false name Gus, because you know what? No one calls him Gus. Right? And he says, I was reluctant to do so, but ultimately signed in under Gus. You will see, right, they signed in the wrong order. They put everyone else above, you'll see above Robin visiting Sue. Robin, the daughter, the witness in this case, Sue being the victim in the case, properly in the right columns. Here, it would be inappropriate, I submit, for this court on the scratch, on what is written in those boxes to say, you know what, because of what this sign-in sheet says or does not say, this case should be thrown out. Here's how you commit second-degree kidnapping. Here's the opposite inference. The opposite inference is that Roger Hillegas knew that he was unwelcome there. That's evidence in the record, that he thought that he had been trespassed from the place. He had not been to see his mom, his elderly mom, in a year. He had not been to this place, believing that he was not welcome there, asked the defendant, Mr. Handte, to sign in for him. Use the name Gus, the fake name Gus. A subterfuge, a fraud, to get themselves back to the locked portion of the nursing home so they could get Mrs. Hillegas and remove her from the facility. Now the issue of, and it is in the record, this interaction with, there's a woman in the lobby who by circumstance used to work there, so she knew or knows at the time Mrs. Hillegas and recognizes her leaving with her son and the defendant, and that raises a red flag. Again, whether the nursing home folks know or do not know the complete legal status of the woman does not change the family court for years upon years, and that's in the record, testimony by his sister, including, importantly, that Mrs. Hillegas's mental status had diminished, right? She had dementia-related problems where she petitioned the court that her mother be placed in this home for her lack of, her serious decline in health and mental capacity. The court said yes. She's going to be placed there. Roger removed as any role in a guardian due to concerns about fraud. He befriends or runs into, or however he comes into contact with Mr. Handte, and they strike up a friendship focused around this issue. Focus, I submit, in Mr. Handte's sort of emotional baggage, he uses similar words, around the death of his own mother. And there is born the conspiracy, and the role that Mr. Hillegas plays is gets a mail order verdict, a thing that is bogus on its face, to someone with 30 years law enforcement experience. It's in the record that he had a law enforcement experience, so he gets this obviously bogus. It's in the record. Piece of paper that he then recruits Mr. Handte, believing because of his law enforcement background, he will have some cachet in enforcing this garbage pleading. Continuing from the beginning, Mr. Handte then believes, and I would say he believes that RPD would enforce his buddy's fake thing because they're in the same law enforcement club. That's fraud. That's that sort of thinking is relevant, right? An inference can be drawn from there that sweeps over and breaks across this sign-in sheet. issue. Oliver Miller says, don't do that. We don't do that. Don't go there. You want to get back into law enforcement? Don't do this. Yet it continues. The next step in that conspiracy is you have Roger go insistently sort of on the disbelief. You don't get special treatment because you're a former officer. Law treats everyone equal. Yet Hillegas goes to RPD and pleads his case. Hey, Stewart Handte was here. He talked to blah, blah, blah. I want to go to this place. I have this paperwork. The sergeant says, hey, this sounds like a civil issue. You know what you do? You go down there and you show them the paperwork. They're going to need some time and management. It might be blah, blah, blah. Doesn't have the paperwork. Doesn't say, hey, here's the paperwork. Telling them, we are not going to get involved in this civil issue. Does that give you a carte blanche to go take the woman? No, right? This is committed without legal authority because the legal authority resided in the orders of this court, the district court, saying her custody is going to be at this home. What do? The opposite. Goes down there, never shows the paperwork, sneaks in, takes the woman. In California, we have testimony that upshows Roger Hillegas with Susan at Truckee at an old friend of Susan's, whereby Roger says, hey, can I use your fax machine? The woman allows it, and he faxes these garbage pleadings to the nursing home. Fraudulent on their face, right? And so you also have testimony in the record that they were talking to him, saying, hey, you gotta bring her back, she needs some medication, what are you doing? Important, right? Across all of these charges, there are inferences in the record which the JP was bound to adopt that support each and every charge. Important too, Your Honor, by this case is charged both direct and vicarious liability as to both defendants. And what I mean by that is, importantly, in a conspiracy and in aiding and abetting, you do not need to show which defendant committed which act in furtherance of the conspiracy, so long as they committed any act with the proper.
The allegation, the affidavits, everything was that they were wrong, when in fact they weren't wrong. He did put Stu, Gus, and Susie. Now, with the Gus, Mr. Stege unfortunately has it wrong because it was Detective Jenkins in the interview in the second or the third, I forget which one, tells confronts actually Mr. Handte with, well, look, Gus Hillegas has sent you emails or text messages, we got them, where he uses Gus. So he's used Gus with you well before anything here. So this idea that you don't know Gus is Hillegas isn't true, and we know it because here we've got text messages where Roger sent to Stewart and he just signed it Gus. So I wanted to clear that up, but we still go back to the same issue because when we look at the information that is filed based upon the preliminary hearing, we have in fact, let's start with, if I could, let's start with the information conspiracy. All it says is they conspired to do a conspiracy, all right? That doesn't tell us anything really. The second one is burglary, and the burglary is what? They went to Stone Valley care place, and what did they do? And then it goes through the boilerplate, and part of it is the boilerplate and specific. The boilerplate, the defendants directly committed the crime. Well, that doesn't tell us anything. Then pursuant to conspiracy, they're vicariously liable. Of course, everyone knows the vicarious liability theory of a conspiracy, but that doesn't give us anything concerning it. It's then where the third thing comes in. They go first by defendant using they did all this by the Roger Hillegas recruiting Stewart Handte to aid in the offense.
Right, while he's on, Mr. Pitaro, if you need to talk to Mr. Handte. All right.
No, I'm ready.
All right, please proceed. I've got the motion to suppress or dismiss that was filed at the end of December. Please argue that.
Thank you, Your Honor. The motion to dismiss the sever, that was filed, I wanted that to be relatively contemporaneously with the writ, because, and the motion to dismiss sever is the same issue. It's the sign-in sheet. And basically what we're saying is the same argument for the dismissal with some additional things that are out there. For example, I think Detective Barnes, who wasn't in front of the grand jury, but the issues that we had out there, that Detective Barnes through discovery had gone out there and got that. Detective Barnes, in his report, showing that he saw that the sheets may have been the wrong sheets. We don't know why that was not communicated, but nevertheless, at this stage, it wasn't. And so the motion to dismiss is basically the same thing, except that what we have in there, the additional, this is the severance, is that we have what we consider would be a Frank's issue. And that is the affidavit supporting the original complaint and the arrest, all the way through this. It maintained the issue of the false signing in, which we now know isn't true. And the issue then comes down to Mr. Hante's arrest based upon that false information, or untrue information. All the way through that leads here, even up to the information being filed in us before you. And what we would do then as the court is well aware, under a Frank's hearing, we would introduce that with that person, show that, and then ask, and then bring Barnes in to show that part of it, and to end up showing that the information was incorrect, and then became independent of the grand jury proceeding. There is supporting the affidavit, supporting the arrest, et cetera, going on. And the complaints, because I don't know how many amended complaints in this case, but there was a large number of them. So that would be what the hearing would have been, because as the court is aware, in a Frank's hearing, when you have a false statement and an affidavit, the court then has to determine, based upon that falsity, how does that affect the original complaint. And so that's why I did it that way. It's not a clean or usual Frank's argument, but the logic is the same.
Well, you're arguing it's a close cousin.
Yeah, I guess that's the way to put it. And I think it is, and I think it's a valid pleading. But that's why I want to be contemporaneous with the writ argument, so that the court can get a little fuller picture of what it is. But at this stage, I think we've given it. If we think we need a Frank's hearing, the court agrees, then we'll have one. But the argument and the motion as writ goes once again back to the issue of the falsity, and of course in the motion to dismiss aspect of it, it would be where how would I put it? Employees of the nursing home pointed out the wrong sheets, and that was in the discovery that we got, who those people were, what they did, and that sort of thing, which may explain why this tragic error started out and never got changed. But nevertheless, that's where it's just a little more icing on the cake concerning the manner in which the false statements got perpetuated during the course of the case. So that's what Barnes would have done, as well as him testifying as to, because I think he could testify as to why he relied upon it and what happened. So that's sort of where it is, Your Honor.
Okay, thank you. Mr. Stege, what's your view?
I will say this strongly, but intentionally.
And let's all make
strong.
sure that the words we choose here are appropriate
Yeah.
for court.
Oh yeah, they are. If there was such a thing as a Franks-related meeting on a non-search warrant case, surely Mr. Pitaro or someone in his office would be able to come up with that case and cite it to your honor. Put more directly, there is no such thing as a motion to dismiss a complaint for what they are saying. No such thing. Does not exist. If it did exist, we would see it, they would lead with it. No such thing. Second, they have a real problem of timing. Now I sense, and I accurately predicted in my last argument, they will double down and triple down and pound the table with this question of the sign-in sheets. But here's the timing problem that they just ignore. The timing problem is at the time of the interview, they didn't have the sheets. At either interview, which was called an interrogation, the first one at Starbucks, the second one at the police station, the first one non-custodial, second one custodial. No babe in the woods, Stewart Handte, 30-year law enforcement officer. A problem of timing. The evidence which they rely on now, right, did not exist at the time of the making of the statement in the declaration supporting PC arrest. However, I go back to no such remedy as the one they request. Our most,
Hold on.
there's
No such remedy, and even if remedy was available, the peg doesn't fit in the hole here because of the timing of when the affidavit,
yes.
the probable cause affidavit versus what the author of that knew at the time with respect to the sign-in sheets?
Yes, yeah, exactly. Even if it were a remedy, they have a real timing problem. Even if it were a remedy, I noted that the PC standard to bind over, very low standard. Looking at the Frank standard, that is an incredibly high standard, incredibly high burden on the defender. On the defendant moving has to show intentionally false or grossly reckless statement was made in support of search warrant. It's all search warrant. And even if you take out that statement and PC survives, assuming, which it's not, Ali Jenkins, probably one of the best detectives in the county of Washoe. You take that out, if PC stands, congratulations, you get no hearing. You get no, they had a crack at the apple at the prelim, you don't get another one because now you want to turn Frank's not on its head, but move it into a different dimension and turn it on its head. So there's no such remedy because we don't want, because it is so rare, it's limited to search warrants, and I want to impress upon the court the reason why it doesn't exist outside of search warrants, and especially in this context of a probable cause arrest with an accompanying declaration. And the reason is that is, one, there's no evidence, right? Like Mr. Handte was arrested in public, right? There's no sort of the Fourth Amendment dimensions of it, right? Frank's is based on the search warrant clause, right? Invasion of privacy, going into someone's home or their body, sort of in extreme circumstances and invading their rights to privacy. That, if there were a reckless statement or intentionally misleading statement made in that, the remedy would lag quite behind the offense, right? If it was an offending statement, it would get you a search warrant, it could be months before a judge reviews it. Opposite here. A PC arrest made in public, brought forthwith by our statutes before a magistrate, entitlement to in this instance, OR, entitled to a PC hearing, a preliminary hearing within 15 days of your arrest. That lots of process, lots of due process there for any, and again, not in the Fourth Amendment search warrant clause arena. That remedy is speed by comparison. And here, applying the Frank sort of doctrine or framework, there's nothing to suppress, right? Once you're in front of the judge and a JP says, I find PC to hold you, and then we'll have a preliminary hearing. Once you're in that arena, there's no super special, sort of outside of preliminary hearing, plus the 72-hour determination, plus your, and I would argue the sole remedy you have is and I think our statute support it, is a pretrial writ of habeas corpus on the question of probable cause. So there's nothing to suppress. Two, Frank's, it's like they say, turn on its head in another dimension. So that heavy burden they must carry to get a hearing, they have not met. But I would, and this is an important, David Jenkins did not lie, right? The evidence that she had with her at the time that was given to her from the witnesses at the scene, what she placed in there. We would not want under these circumstances that a Frank's hearing be ordered.
I understand your position. Mr. Pitaro.
Yes, Your Honor. Let me briefly, that's the way it is. But the court does point out the most obvious fact, and that is Mr. Handte is in custody, unfortunately now in a wheelchair, based upon falling, tripping, whatever, passing out, and I think it was an alcove, and is getting minimal treatment, more pain pill type treatment than trying to resolve the problem.
But you know that the state, and sorry to cut you off, but you know Mr. Stege shortly will say, Judge, we need an explanation as to why he was picked up heading east. We need to know why he was with Mr. Hilligus. We need to know that this community is protected if he changes custody status. I mean, I'm gonna need some answers to these tough questions.
Let me, Your Honor, at the time that this happened and what it is, Stewart Handte was under incredible emotional distress. Him and his wife had broken up. His wife had left him. His wife had taken everything they had, including his dog. And I have dealt with those sort of situations, I'm sure you have, and they're difficult to deal with. The emotional aspect of that, I think if the court would take that into account, and then the issue that it is his wife was saying that she found a gun that must have been there sometime during the 9-year marriage. Mr.
And
Handte,
hence the court's order to just recertify him
I
having
understand.
firearms. I didn't put him in jail because of that. I
I
didn't
know you
increase his
didn't.
bail because of that.
and
I took the defense argument at its word, that this is not a new gun, this was not a threat to himself or this community. I balanced that as well as the court could.
And I recognize that, Your Honor, I do, I understand that. The problem that we were facing at the time was Mr. Handte was emotionally distraught concerning it. He believed that if he had from the case and the way that the hearings had transpired in court, and the court was aware of it with Mr. Hilligus and wanting the Ferretta, and then Mr. Handte wanting it, and those sort of things. And so he felt that the ankle bracelet was somehow a danger to him. He was trying to find out whether you can listen in with ankle bracelets, and as the court is aware, you can't, depending upon the ankle bracelet, the way they're done. My impression was that the ankle bracelet we were talking about in this case was not that type of a device, and you weren't having the monitoring of it in any event. But nevertheless, that's where he was coming from. So he was fearing for his life.
And, I'm sorry, Your Honor, I have to. Our statutes contemplate that this is an evidentiary hearing. The history of this case causes me, I have known Mr. Pitaro for a long time, to not want to hear Mr. Pitaro sort of make, sort of aspirational statements or guessing statements, but I would want this court to rely on statements of some evidentiary, quality.
Well, I'm going to assume that at some point, if Mr. Pitaro was asking the court to accept these representations factually and balance them in determination, I'll have to hear from his client under oath to confirm what the court's being told by way of argument. Now, there's a fine line though, because some of this is an argument that the court can make some informed extrapolations from the process. Others comes over the line, and I would have to hear from the person who apparently is under this impression. So, objection noted. You may proceed, Mr. Pitaro. But for the teeth to be in this argument, at some point I would like to hear, if you want to have them on the stand, from Mr. Handte as to where he was going and his impressions about what caused him to act the way he did.
We will do that, Your Honor, if I could though.
You may proceed.
And then we can do it. And so we have.
We are gonna have a leg stretch break here in a little bit, probably after this hearing and before the next one, but go ahead.
Oh, okay. And I guess what I'm saying, there's that stress that was out there, what his beliefs were, whether they were rational or not, they were his beliefs. I guess that's the point I'm making. He was in Elko. It wasn't like he had been given a restriction on where he could go. Of course, that sort of begs the question, because he should have had the bracelet on at that time, and I understand that. As far as, yes, I think the bracelet under these circumstances, and as we are here today, is appropriate, and Mr. Handte agrees it's appropriate, and that there's ways to challenge court's orders, and ignoring them is the least intelligent one to do, like he did. The other thing is, Your Honor, there was the talk, and it's in Mr. Stege's motion, and given what the court did with Mr. Hilligus and the problem there, I spoke to Mr. Handte in that time frame the court allowed us to have, and he agrees that it'd be appropriate for him to be examined, as Mr. Hagee in the court had alluded to at one time, that to see what is happening and what he can do to counter the stress. And so the court can have an idea of what it is, just as Mr. Hagee suggested, and I spoke with Mr. Handte, and I told him I can think that is a reasonable thing.
Well, there's a bit of an issue there, because on the one hand, there's having mental health exam for the purpose of finding out what you have going on and whether there's ways to respond to it in a healthy, productive way. And then there's an issue if somebody believes that there's a competency to proceed to adjudication. That's a bit different than the first one. And often I'm asked by defense counsel to pause proceedings and direct represented clients for competency evaluation for purposes of proceeding to adjudication. Other times the court does it sua sponte, as I have with Mr. Hilligus. Occasionally the state makes the ask, and then the court weighs everything and makes an informed decision. The state, I believe, did make the ask, and the court declined to do it. And I try to use the court's words very diplomatically at this time. And so I want to make sure I understand what you're saying. You're not suggesting that the court should re-look at its prior order denying the state's request for a competency evaluation. You're suggesting that your client might have some mental health concerns and he wants to get on top of them. Is
Yes,
that
Your Honor.
fair?
Yes, Your Honor, and so I'm not asking, as you know, the attorney not only comes to the court and says, I think I have an incompetency.
So that's not where you're at, right?
I'm not a dusty issue, no, Your Honor. I'm, I guess something less than that, and I think was what the court might have been talking about, and the same sort of thing with Mr. Hilligus. I assume that's what
Well, with Mr. Hilligus, I have concerns about his competency to proceed to adjudication. In his case, is state pending evaluation by two
Right.
licensed professionals. Let me just say this, if I find somebody who's being a defendant in a criminal justice case who has some mental health challenges and they want to work on themselves to get in a better place, I certainly don't stand in the way of that. I think it's a sign of strength to realize you've got something going on and not be ashamed to admit it and try to work on yourself. But for purposes of this hearing, if you want me to hear from your client that what caused him to fail to abide the court's order was a combination of things, one of which is being emotionally distraught over the case, over his family marriage or something else, I'm certainly willing to consider that and decide how to proceed going forward.
well, and Your Honor, I think Mr. Handte would welcome that, the opportunity to do that to the court given that opportunity. Just to the only, before you, the other issues are, the issue of monetary bail. He is basically destitute now. He makes approximately $2,100 from his state pension, and that is the extent of his income. He obviously lost his job. Once he went into custody, obviously consequence of it. And he also has this back issue. He's got to resolve that back issue, probably before he's able to gainfully get back to work. So he's got to get to a doctor to help him on that, as well as these other issues. I want to just, the court to consider that.
All right, so let me, I'll hear from your client if you want me to place him under oath in a moment, and you can ask him some questions. But here's what I'm taking away from this part of the defense argument. He was emotionally distraught. He understands better now that court orders to be followed are not optional, at least until and unless they're rescinded or modified or expire. That he is willing to wear a tracking device. He's willing to recertify he owns some firearms, and he's compliant with the other terms of his pretrial release. And he'll stay away, well, I didn't hear you say this, but I'm assuming he understands the importance of staying away from people connected currently or have been in the past from this case.
Absolutely.
And you also say for purposes of making bail, he has no money other than his current income right now. Of course, as Mr. Stege will observe, the ability to make bail is not determinative. Of course, the financial status of somebody who's in custody on bail can be a consideration that courts use.
And I understand that's from the law, whatever, but that's a very harsh interpretation in individual cases. And I think all courts look at that as one of the considerations. If courts just say, okay, I'll make $1 million for everyone, then obviously we don't have real bail.
Yeah, we don't do that.
I don't think we're there. I think the court will honestly look at his financial condition.
Okay. Would you like me to hear from your client?
Yes, Your Honor.
All right. Here's my approach. What I'd like to do is a couple things. One, again, deputies who are supervising Mr. Handte either at the jail or responsible for transporting him here. Is there any concern about public safety if we also release Mr. Handte's other arm? Because when somebody testifies, the court often likes to see the manner in which they speak, not just the words they say, and to have somebody restricted, although I certainly have done this before, can sometimes interfere with that. So who can address the court? Because if there's not a safety concern, I would like his left arm unchained, but if there's a safety concern, I'll respect that and defer to the officer.
No, you can remove his.
All right, if you would, please. Second thing is this, ordinarily I'd have Mr. Handte come up to the witness chair, but he's in a wheelchair, and unless somebody objects, I would just as soon have him stay there. Council can sort of slide their chairs so they're facing Mr. Handte. Mr. Handte can slide his chair so he's responding to the person asking him a question. And that way I don't have to have him come to the witness stand. Mr. Pitaro, is that acceptable to Mr. Stege?
Yes, thank you.
All right, so Mr. Handte, please raise your right hand. Ms. Gaynor will administer the oath of witness.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you, Mr. Handte. You may put your hand down. And Mr. Pitaro, again, feel free to turn your chair or look sideways. And Mr. Handte, same thing, please look at the person asking you questions. You may proceed.
Mine is, if the court wishes to address him, I would prefer that the court address him.
Well,
right now.
here's, I'll let you ask him the questions, but where was he going? Will he abide the court's orders? Does he have no money? Does the public need to be worried that he's gonna do something that, not only violates the court order, but puts the community at risk, things like that?
Okay. Mr. Andy, first of all, why didn't you go down and have the bracelet put on as the court ordered you to?
Because as I stated previously, I was in fear of my life due to certain enemies I made in this community. As a long-standing resident, 45 years, 47 years to stay in Nevada, including a 30-year law enforcement career. And I wanted to find out further about the GPS tracking device, about the eavesdropping aspects. We were heading to Elko to meet a gentleman who was acquainted with Mr. Hilligus. Obviously, Mr. Hilligus is not around to testify to that, who was an electronics expert. And he did not want to talk about anything over the phone. He wanted us to go there in person. I did not have any travel restrictions on me that were placed on me. If I intended to flee the area and not and escape the court's rulings and statements, then I would have probably done it on Tuesday. However, this took place on Wednesday. And we were traveling to Elko. We were planning to travel back to Reno the following day.
Did you pack, when you were with Mr. Hilligus in Elko, did you pack clothing sufficient for you to be leaving?
I packed a small overnight bag because we were going to stay at the hotel in Elko and then head back today. I didn't have any luggage. In fact, all of my personal belongings were at the room I used to rent on 8065 Shifting Sands Drive, including the cremated remains of my mom and dad.
And after Elko, where were you going to go?
Back to Reno.
Now, the court has raised obvious concerns of, will you tell the court why you were not a flight risk, that is, leaving?
I was not a flight risk, nor was I intending to go to North Carolina to visit my estranged wife because she's the one who left the marriage and abandoned me. I was coming back to Reno. I've lived in Reno most of my life. My family members are here today to testify to that. I intended to continue my employment at the place I was working at. And I was going to find out specifically from the gentleman in Elko about the electronic monitoring devices. And if he was able to give me some assurances that they would not be able to be eavesdropped on me based on limited information I had, I was willing to do that, as I am today. However, we never got to that point because I was taken down outside of Elko by at least 7 law enforcement officers.
So you're taking custody there and then ultimately transported here back to Washoe County for this hearing?
Correct, and to elaborate a little bit on my current medical situation today, Judge, my back was injured when I was taken into custody on August 14th of 2019 by excessive force. My back has never recovered. When I was placed in the detention facility in Elko, I was placed on a concrete hard floor with only a blanket for 3.5 to 4 hours. When they told me to get up, I did, and my back locked up and I fell and re-injured the previous injury that was taking place in August of 2019. That's why I'm in the wheelchair today.
And you're in the wheelchair since?
Correct.
And what is your medical treatment within the facilities?
Pain pills to kind of subside the pain that's taking place. It's no longer excruciating as it was in Elko when I was denied medical evaluations and doctors. I was taken to the hospital after the injury occurred, and they were giving me something in an IV that took me to a whole different situation. And then they tried to inject me with something, which I didn't know and I refused. And then I blacked out because of the pain and because whatever they injected into my intravenous drip inside the ambulance. That's when I woke up in excruciating pain. I've only seen one doctor at the Washington County Sheriff's Office, and he actually left his employment there last Friday, so I was basically told he was in quote-unquote checkout mode for a matter of time. He was a general practitioner. He's not a chiropractor, he's not a neurologist, he's not a back doctor. I tried to ask him questions about that, and he said that's outside of his medical capabilities. And of course, he no longer works there.
I want to address also, you were in release this case around about 2.5 years now.
Yes, sir.
Did you ever violate any condition of your release up until the ankle bracelet?
I did not, and no records can prove that.
And did you make all your turn-in time?
I made all my Zoom appearances, and I made all my call-in appearances, and I updated, my first intake officer was Carlos Mendoza, then we had Mary Morris, there was a third one, and then we had Cody Meredith.
Who's here in the courtroom?
Correct.
All right, now, and so during that period of time, you abided by all the regulations?
Correct.
Is there any reason that anyone should fear you physically, of you going out and doing any harm to anyone in the community?
Despite what the state has said in reports, I have not threatened anybody. If so, there have been police reports, especially over social media, Judge. That's a domestic terrorism act, that's a federal offense. I've not threatened anybody. I've not insinuated to threaten anybody. I've stood defiant against allegations against me, and that's my right under the First Amendment. So therefore, I've never threatened anybody. There's been no police reports ever. I've had an unblemished criminal record up until this illegal arrest in August of 2019. I've had a distinguished career in law enforcement, nationally recognized, state recognized, and locally recognized. So there is no statements that I've ever been fired from any law enforcement job. That's a lie. And that's been put forth by the state as well. I've never threatened anybody. And there are family members in the audience who can attest to that as well.
What I'd like you to do is tell Judge Breslow whether or not you will abide by all his orders if he would release you under conditions that you can meet.
I will abide by your orders, Judge. I need to get my back fixed. I don't like being in pain. I want to be productive in society again and attain another employment aspect. And if I'm in a wheelchair, that kind of limits my abilities. I'm not planning to leave Reno. I'm planning to fight these charges all the way up until jury trial. And my family members, when I moved out here in November 1974, are the audience today, and I thank them both. I have roots here, again, 45 plus years living in Reno. I'm not going to North Carolina, Judge. That would be kind of an oxymoron to go visit my estranged wife who's going to file for divorce. I don't think that would be applicable. I plan to stay here, and as long as my life roots continue to stay here in Reno, which I believe they're going to be, this is where I plan to stay. And again, there's never been any threats against anybody. I may have stood defiant in my First Amendment rights, but that's protected under First Amendment law. And Mr. Stege knows that. If there's been any threats, or any insinuations of threats, especially coming from a law enforcement career of 30 years, there would be police reports, Your Honor. And I will abide by the court's order, as I did when I had to transfer the firearms over to a gentleman who's actually in court, this court today, Mr. Swift.
And you have no firearms now?
I do not have any firearms. I never had any firearms in my possession after they were turned over to Mr. Swift. He can attest to that as well. Whatever my wife saw, she saw. I don't believe what she saw, I believe she saw something else. And she has her own guns. Maybe she saw her own guns and mistook it for my gun. But my firearms, my pistols, have been in possession of Mr. Swift ever since I turned them over under the court ruling and voluntary agreement with Judge Sullivan and the Justice Court.
Mr. Pitaro, let me hear from Mr. Stege, then I'll let you respond to what Mr. Stege says, any questions he asks of the client, and any evidence he'd like the court to consider. Mr. Stege.
Thank you.
And excuse me one second. So we've been going, not quite.
Alex here, and this is when they apparently went for a recess. The missing footage is approximately an hour, maybe an hour 15 minutes long. This is the point at which Channel 8 camera personnel left. The docket itself indicates that on March 4th, 2022, an order was entered, so I can at least go over the title of the order. Apparently, the petition for writ of habeas corpus was denied. The motion for gag order was granted in part. The motion to suppress/dismiss was denied. And the reduction of bail motion was also granted in part. I don't know the details or the specifics because the website of the Second Judicial District Court does not allow you to download PDFs. I may be able to get the PDF in a roundabout way later on. If I do, I will post it down in the description below. The transcripts also, we can get those. They have to be purchased, and I most likely won't bother to get these. The written order will probably suffice, but if anybody was interested in the transcripts, those usually cost somewhere in the ballpark of $80. And if somehow, some way we end up getting the transcripts, we'll post those down in the description below.